The Senate Committee on General Laws will come to order. Mr. Secretary, please call the roll.
Karaoke at the microphone if you want.
There you go.
Yeah, that's good. I might just sit up there.
I was just talking with somebody about starting doing karaoke.
I cannot.
Oh my God. We did 3 hours of it during Thanksgiving.
Oh, I was
In Colorado.
I was going to say,
Oh, there we go. It's back on. Perfect.
oh, I see. Drama of a different kind.
So, a quorum being present, I make a motion that we go into executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. We're in executive session. I next move that we bring Senate Bill number 1064 before the committee. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. Senate Bill number 1064 is before the committee. As folks will recall, this is the tobacco products preemption legislation by Senator Brown. I make a motion that Senate Committee or that Senate Bill 1064 be voted do pass. Do I have a second? It's been seconded. Any discussion? Seeing no discussion, Mr. Secretary, please call the roll.
Chair Trent.
Aye.
Senators Gregory. Bernskoetter. Carter. Coleman.
Aye.
McCreary.
No.
Weber. I got 4-2.
By your vote of 4 ayes and 2 noes, you have voted do pass Senate Bill 1064. I next make a motion that Senate Bill 1202 be brought before the committee. Do I have a second? It's been seconded. The bill is before the committee. I next make a motion that the committee vote do pass Senate Bill 1202. Do I have a second? It's been seconded. If everyone will recall, this is Senator Hudson's bill related to assessments on broadband communication equipment. Any discussion? Seeing no discussion, I renew my motion that committee vote do pass Senate Bill 1202. Mr. Secretary, please call the roll.
Chair Trent.
Aye.
Senators Gregory. Bernskoetter. Carter. Coleman.
Aye.
McCreary.
Aye.
And Weber. 5-1.
By your vote of 5 ayes and 1 no, you have voted do pass Senate Bill 1202. I next make a motion that Senate Bill number 916 be brought before the committee. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. The bill is before the committee. I next make a motion that we adopt Senate Committee substitute for Senate Bill 916. It has been distributed, and I move for its adoption. Do I have a second? It's been seconded. If everyone will recall, the Senate Committee substitute is the actual version that was presented by Senator Berger. In our last hearing, this is the sovereign immunity liability private contractors language. Any discussion on Senate Committee substitute? Yes, Senator Coleman, please proceed.
I have spoken with Senator Berger, and I'm happy to help get this bill out of committee. I understand the work that he's trying to get done and happy to help with it, but I don't believe we're quite ready for there will be more work that will need to be done on this, and I look forward to being a part of that.
Further discussion on the adoption of the Senate Committee substitute? Seeing none. All those in favor, I renew my motion that the committee adopt Senate Committee substitute for Senate Bill 916. All those in favor, please signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. You have adopted the Senate Committee substitute. I now make a motion that the committee vote do pass Senate Committee substitute for Senate Bill 916. Do I have a second? It's been seconded. Any discussion on the motion? Seeing none, I renew my motion that the committee vote do pass Senate Committee substitute Senate Bill 916. Mr. Secretary, please call the roll.
Chair Trent,
Aye.
Senators Gregory, Bernstein, Carter, Coleman, McCreary, and Weber.
Yeah.
14. What you want to vote?
The other person, the chair.
Did you submit them in writing?
Dennis told me that he submitted our votes because I wasn't sure I was going to get down.
I didn't get it, so that's all right.
Well, we will find and incorporate your vote.
Thank
So it'll
you.
be fine. By your vote of 4 aye and 2 no, you have voted do pass Senate Committee substitute for Senate Bill 916. Next, make a motion that we leave executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed to contrary? The ayes appear to have it. The ayes do have it. We are out of executive session. And we will begin with public hearing for Senate Joint Resolution number 87. Senator Carter, if you are ready, please proceed. We will also, because of the shortness of time, not only will I talk very fast, but we will limit testimony to 2-minute increments. We will try to accommodate as many witnesses as possible. So if everyone would please be mindful of that limitation, we will also have a timer that will indicate when your time has expired. We're going to limit everybody.
Mr. Chairman, committee members, I appreciate the opportunity to present this bill. This will be I think our 4th year presenting this piece of legislation. This is an SJR dealing with our sheriffs and the ability for our sheriffs to be in our Constitution as a designated office. So right now, they're just statutory. We'd like to transition that into a constitutional, office so that some future time there's somewhat of a movement to eliminate the office of a sheriff. We believe that law enforcement should be accountable to their constituents, and for the ability for them to vote in and have a voice on who serves as that official in that official capacity is really important. So with that, I'll answer any questions. We have some people here, I think, to testify. So
Questions for the bill sponsor from the committee? Yes, proceed.
Is this the exact same language as last year?
yes,
Okay.
it's passed the Senate last year. We just didn't quite get it across the finish line in the House, so we're taking another stab at it this year.
Okay.
Thank you.
Any further questions for the bill sponsor from the committee? Hearing none. Thank you for that presentation. First witness testify in support. Please make sure if you plan to testify that you filled out a witness card and proceed when ready.
There we go. Mr. Chairman and members of the committee, thank you for the opportunity to testify today. I'm Michael Bonham. I'm the Sheriff of Osage County. I'm also representing the Missouri Sheriffs United. This amendment, Article 7, Section 15 of the Missouri Constitution regarding the office of sheriff, at its core, this resolution is about one simple but powerful idea: accountability to the people. Sheriffs in Missouri are and should remain chosen by the voters of their county, not appointed, not installed, not controlled by political bodies. When citizens elect their sheriff, they know exactly who's representing them for public safety. And as if a sheriff fails to lead with integrity or competency or courage, the people can remove him or her at the ballot box. That's how the Constitution Republic is supposed to work. This resolution also does some critical importance. It clearly established the sheriffs as the chief law enforcement officer in the county. In times of crisis, whether it be civil unrest, natural disaster, violent crime, there can be no confusion about who's in charge. This resolution provides that clarity and ensures that when order needs to be restored, the sheriff has both the authority and the responsibility to act. Another key strength to this resolution is that it protects the sheriff from political retaliation by limiting the removal by writ of pro quanto initiated by the Attorney General. This resolution ensures that the sheriffs can enforce the law without fear of removal of their office from political reasons. That independence is an essence. We do not want the sheriff who is worried about pleasing politicians. We want sheriffs that are committed to doing what is right under the law. This resolution also reaffirms the tradition and constitutional role of the sheriff, keeping the peace, executing court orders, and ensuring that justice is carried out. I will yield.
Thank you for that testimony. Any questions for this witness? Yes, Senator, please proceed.
So, are there some counties in the state where sheriffs are appointed by commissioners, I presume, or?
Yes, well, the St. Louis County Sheriff is, and then we have some oddities where St. Charles, their sheriff is now more of a figure. They have the St. Charles Police Department, and St. Louis is a bridge unto its own.
So, but it says the constitutional amendment shall not apply to St. Louis City, St. Louis County, or St. Charles County.
So those are because the voters have voted for what they have. They have been, by population, been taken out, yes.
So as far as it goes right now, every other county in the state is currently elected, and we're just codifying that?
We are placing them so in future that it cannot be changed by political divisions to remove the sheriff or change the status of the sheriff, as other states have, like Connecticut, they have done that. And they have removed the sheriff, and they have a state police model, which then is controlled by the governor.
Okay, thank you.
Further questions for this witness? Hearing none. Thank you again for being here. Next witness testifying in support, SJR87. And I believe there might have been some individuals in the hallway. If someone could call the hallway real quick.
Senator Trent, I believe I'm the only one that was going to testify.
Oh, okay. All right, thank you for that.
I think they opened it up now.
Oh, okay, thank you for that. Any witnesses here testifying in opposition for SJR 87? Seeing none. Are any witnesses here testify for informational purposes only? Seeing none. Any concluding remarks, Senator?
I appreciate your time, committee members and Mr. Chair, and thank you so much.
I was for, sorry.
Certainly, we'll take one additional witness in support, since you were trapped out in the hallway.
There's a number of people, there's probably about 30 people next door, so. Thank you very much, Mr. Chairman, members of the committee. My name is Arnie C., AC Dinoff, State Public Advocate. I'm in favor of this SJR. I think it's very important to have a constitutional sheriff to ensure our historic background and how we started as a country. There needs to be one chief law enforcement officer. I believe it was brought up in testimony with the sheriff who testified. There is St. Louis County, and I believe one other county that I think it's not the city of St. Louis, but there might be one other county that has an appointed sheriff. In St. Charles County, we're kind of unique. We voted to change our county charter to separate the functions, to have law enforcement functions done by a police chief and a police department, but remain the functions of sheriff to do process service of civil lawsuits, in charge of prisoner transport, and bailiffs in our court judicial administration building. But we still have an elected sheriff. So I would like to change the law that all 115 counties, including the city of St. Louis, has an elected sheriff, that the people get to choose and vote for the sheriff. Let's not have special caveats or special carve-outs for special counties. I'd like to see St. Charles County return to an elected police chief along with an elected sheriff to ensure that there's one person in charge for different functions. And so that's my testimony. I would appreciate having the vote. I'm sure Missourians would like to have the vote on this constitutional amendment to once and for all put this issue to bed and make sure that it's adhered to and written within our Constitution. Thank you, Mr. Chairman.
Thank you for that testimony. Any questions for this witness from the committee? Hearing none. Thank you again for being here. Were there any other witnesses in support? Seeing none in opposition? Seeing none in for informational purposes only? Seeing none, that will conclude the public testimony, public hearing for SJR87.
I don't see him. I'll text him. Do I hear yours?
I'm just going to go ahead and hear mine. We will next proceed to public testimony, public hearing for Senate Bill 1120, and I will turn over the committee to the Vice Chairman for that portion of the hearing.
All right, going public hearing on Senate Bill 1120, sponsored by Mr. Chairman, Senator Trent. Please go when you're ready.
All right, thank you, Mr. Chairman, members of the committee. Curtis Trent, representing Senate District 20. This is Senate Bill 1120, which is the time-limited settlement demand to liability insurers bill. Essentially, what we're trying to do here is create a strong guardrail around a period of time that we want for insurers to be able to respond to claims for liability for settlement. There is when an insurer gets a claim, there is a certain amount of information and facts that have to be gathered in order to ascertain the validity of the claim and to make a determination to pay out a settlement. I believe that a reasonable time period that they should have in order to make that determination would be 90 days. That's what the language of the bill would require before any kind of non-contractual damages can be brought against the insurer by the plaintiff. I think this will help lower costs of litigation, lower the amount of litigation that occurs in the state of Missouri, will ultimately result in lowering of cost of insurance for all of the ratepayers, policyholders in the state, while still making sure that people have the ability to settle these claims, and if bad faith does occur, to bring non-contractual damages. So with that, I'd be happy to answer any questions from the committee.
Any questions for the bill sponsor? All right, seeing none, we'll go witnesses in favor of. And again, I'm assuming most everyone's in here to testify on this bill. Okay, first couple witnesses, we'll go a little bit longer so you can get some points across, but please keep everything fairly conclusatory and don't replow ground that's already been gone through.
Thank you, Mr. Vice Chairman. Members of the committee, my name is Clay Crawford. I'm a Missouri policyholder. I'm also an attorney, past president of the Missouri Defense Lawyers, and a fellow in the American College of Coverage Council. I'm here to testify on SB 1120. Senator Trent did an excellent job of explaining why the bill is necessary. Why are we here? 537058, the statute to be amended, was just passed in 2017. The legislative intent behind that bill was plain and simple: to give insurers who might be exposed to 10, 20, 100 times their contractual limits of liability a fair opportunity to consider settlement demands when made. The legislature determined that 90 days was a fair amount of time, and that period of time was taken from the prejudgment interest statute, which only exposes insurers to maybe 3 to 10% of prejudgment interest as a penalty for not accepting settlement demands. Bad faith claims may expose those same insurers to 10, 20, 100 times their policy limits if not accepted. So they should have a fair opportunity to accept settlement demands that are made within their limits. As soon as 537058 was passed, the plaintiff's bar changed tactics. The witness this morning on the House bill admitted that for years, decades in Missouri, the problem was that settlement demands were made with short time limits. 537.058 put an end to that. But the plaintiff's bar changed tactics, and they started making untime limited demands with conditions that were very difficult for insurers to meet before they could unilaterally withdraw the settlement opportunity from the insurer. These are conditions like obtaining affidavits from insureds or their household members, financial statements from insureds, affidavits from employers, recorded statements, even examinations under oath, which are like depositions before there's even a lawsuit. It became very difficult for insurers to meet all of those conditions and actually accept settlement demands. Do not be fooled. These amendments to this bill will not result in delays in routine claims handling. We already have an incredible number of insurance regulations in the Unfair Claims Settlement Practices Act, overseen by the Department of Insurance with market conduct exams to ensure that claims handling is timely performed. The amendments to this bill are aimed towards putting, as Senator Trent said, guardrails around the types of settlement demands that might be used to set up bad faith claims and expose insurers to substantial extra contractual liability for millions and millions of dollars, the cost of which is ultimately borne by Missouri policyholders like individuals and small businesses. Thank you.
All right, thank you for testimony. Any questions for this witness? Senator Weber.
So I wasn't here in 2017. This current statute that you're trying to change was passed then?
Yes.
And who wrote that, or who's responsible for drafting that?
I do not know who. I think there were a number of industry participants who were involved in the drafting, various insurance companies, the Missouri Insurance Coalition. I should have mentioned I'm here on their behalf today as well.
So it's kind of a team effort, a lot of folks involved in it?
As far as I know, I was just an expert, not a lobbyist. So.
Okay, I just want to make sure that, first off, I understand drafting something and wanting to change it, but I'm just curious how many, are you confident you got it right this time? How many bites of the apple are we going to take at this? Are we going to be back every few years redoing statutes that have been passed? Because I imagine it was quite a big fight in 2017.
I don't know how big a fight it was, but I know that the problem was clear. It was acknowledged this morning by the opposition's expert. This was a giant loophole that was opened that I think this bill would close, and I think I don't know what the plaintiff's bar might do in response, but I think this will close the loophole that is creating the major problem with trying to settle, giving the insurers the opportunity to settle these demands before they're exposed to millions of dollars in extra contractual liability that they didn't underwrite, didn't charge premiums for.
Okay, I just wanted to understand the process, because I know that these are heavy lifts, and obviously it sounds like from your perspective, not from mine, but from your perspective, it sounds like mistakes were made in drafting this current law, and I just wanted to make sure that we are on the same page about making sure that if you guys are going to try to keep making these heavy lifts, that you're not making errors and then having to lift the same thing over and over again, if that makes sense.
Senator, the only thing I can say in response to that was that the problem that was acknowledged this morning, which were the previous practice of making short time limited demands, that was stopped by 537.058. It's just that a new problem developed.
No, I understand. Thank you.
Further questions for the witness? All right, seeing none, I want to go first witness in opposition, and then we'll roll through the for and against. I had on the clock about 3.5 minutes of testimony from the first witness in favor of. So first witness in opposition, you get about 3 minutes and 30 seconds, and then we'll roll through each side. And please proceed when you're ready.
Mr. Chairman, members of the committee, my name is Randy Alborhaski. I'm a personal injury and workers' compensation attorney in Springfield, Missouri. I'm also here on behalf of the Missouri Association of Trial Attorneys. This is a bad bill. This is an anti-consumer, anti-victim bill. It's going to promote the lack of diligence and obstruction on behalf of insurance companies. And it's going to make it virtually impossible for individuals without an attorney to settle a case which easily meets and exceeds the insurance limits, because they can't meet the tedious paperwork that's required by this bill. I could tell you many times people have come to my office and it's an insurance policy limit case, and I'll say, you don't need an attorney. Just make a demand for the policy limits, and that you don't need to pay me. And they do, and that works. But when the insurance company knows that they can avoid that they can ignore a fair, reasonable settlement negotiation, and instead put off the victim, the person who was injured by the negligence, put them off until they either go away or settle for less than policy limits or hire an attorney, then what are they going to do? Of course, they're going to lowball the victim and make them either go away or make them hire an attorney. The end result of that process, of course, is going to be the ones who hire an attorney are going to get more money. They're going to get the insurance policy limits, or they're going to not hire an attorney, and they're going to go away with little or nothing, even though they may have $100,000 in medical bills, and there's a $25,000 policy. In essence, this gives the insurance companies the right to deal in bad faith and have no repercussions. I heard the representative from the insurance industry speak earlier about how this was going to save litigation costs. I don't think that at all. I think what's going to happen is, in the end, people see advertisements anymore. They see, attorneys on TV, and they think, well, if I'm getting messed with, I'm going to hire an attorney, and at least I'll get my policy limits I'm entitled to, so I can pay for my medical bills. So in the end, when they lawyer up, then of course defense company lawyers up too, and litigation costs skyrocket. So it may be well intended, I don't know, but I don't think it'll be effective in the intended purpose of the bill. The last thing I would say is this. There's a reason why we have bad faith, and there's a reason why bad faith judgments are so much higher than regular judgments if you just have a judgment for injuries and damages. And the reason is to make the insurance companies come to the negotiating table and pay what they need to pay, what's reasonable and fair. This bill removes that incentive from the insurance companies. They will virtually have no incentive to settle a case and deal reasonably and fairly with the injured. With that, I'd be glad to answer any questions.
Great job. 3 minutes and 20 seconds on the button. About perfect. All right. Any questions for this witness? Seeing none, thank you for your testimony.
Thank you.
Okay, we're going to roll through everybody that's in favor of now. Try and keep it around 2 minutes so we can get everybody through. I know there's some people on the other side of the room also.
Good afternoon. Dana Fries, President and CEO of Healthcare Services Group in Jefferson City. We are a hospital member-owned insurance organization celebrating 50 years in the state of Missouri this year. Testifying today on behalf of the Missouri Organization of Defense Lawyers and the Missouri Hospital Association. As the president and CEO, the buck stops with me when it comes to handling claims. We are in the business of settling claims, not taking cases to trial. We settle over 95% of the cases where an indemnity payment is made. That's what we do. This is simply trying to close a loophole that was not apparent back in 2017 when we all worked on this bill. It's apparent now. And this bill is a simple, straightforward approach to addressing that loophole. Is there a problem that needs to be fixed? There is. It's the cost of insurance. Insurance companies like mine buy reinsurance. What is the first thing they ask me about is what's going on with bad faith claims? Have you been sued for bad faith? What's going on in the state when it comes to bad faith? Well, we've not been responsible for a bad faith outcome, but other insurance companies has. It affects the rates I pay, which I pass on to my customers. Just before I came over here today at noon, I had a call with our outside insurance rating actuary. And what did they ask me in that call this morning? What's going on with tort reform? What's going on with settlement environment? They care. They set the rates for our member hospitals. So I want to know what the rules are. I want a reasonable amount of time to settle the claim. 90 days is reasonable. If I can't resolve it within 90 days, then it's on me. But it should not be a constant situation of moving goalposts. Thank you.
All right. Thank you, sir, for your testimony. Any questions for this witness? Senator Carter.
Give me an example of the goalpost moving.
Well, I'll give you a great example. There was a Missouri Court of Appeals decision that came down on December 3, 2024. The name of the case is Escabusa versus Safe Auto Insurance Company. It was an auto accident case. $25,000 policy limit. The insurance company offered its policy limit to 4 different attorneys representing the plaintiff, including 2 lawyers from the same law firm that made different demands. They offered their policy limits 9 different times during that case. They still got sued for bad faith. And the Court of Appeals had to take this up on appeal. And the Court of Appeals said the insurance company did not act in bad faith, that there were moving targets, moving goalposts of what the plaintiff's conditions were in order to pay that money. That's the problem we're trying to resolve. The Court of Appeals said in this opinion that the insurance company is entitled to a reasonable amount of time to investigate and settle a claim. This statute establishes a reasonable amount of time. So not only are we attempting to reinstate the public policy intent that was adopted in 2017, but we're also codifying here what the Court of Appeals said in 2024, which is that an insurance company should have a reasonable amount of time and they should know clearly what the conditions are to settle the case and not have moving conditions trying to trap the insurance company, as was the case in the Escabusa case. No insurance company should be forced to have to offer their policy limits 9 different times and still be subject to a bad faith claim. And think of all the money that was wasted having to take this up on appeal. And the end result was the insurance company didn't do anything wrong. But the plaintiff lawyers were looking for a windfall here. They didn't want that $25,000 policy limit. They wanted multiples of that by trying to trick the insurance company into making a mistake. So this Escabusa case is the perfect example of what we're trying to remedy in 2026.
So if I understand what you're saying correctly, and correct me if I'm wrong, there are basically 2 contingencies to your argument. That one is a time frame, and then the other is conditions. Is that what you're saying?
That's correct.
Okay, I appreciate that. Thank you.
Thank you, Senator.
Further questions for the witness? Seeing none, thank you, sir, for being here. Witness in favor of the bill. Any further witnesses in favor? Please proceed when you're ready.
Good afternoon, Mr. Vice Chair. Hampton Williams with the Missouri Insurance Coalition. Yesterday I distributed a letter in support of this to everyone, so if there are any questions regarding that, that will be my testimony.
All right,
So if there are any questions, happy to answer.
Questions for this witness? Seeing none, thank you, sir.
Thank you.
Next witness in favor, Senate Bill 1120. No.
Good afternoon, Mr. Chair, members of the committee. Jared Hankinson, representing the Missouri Chamber of Commerce and Industry. I'll follow suit from the testimony before. Happy to go on record in support. Happy to take any questions.
Thank you for being here. Any questions for this witness? Seeing none, next witness in favor.
Good afternoon, Matthew Smith with Associated Industries of Missouri, going on record in support.
Questions? Senator Carter.
What did you say your first name was?
Matthew.
Thank you. I appreciate that.
Mr. Chairman, Brad Jones with the NFIB, and we would also like to register our support for this bill.
All right,
Thank you very much.
Thank you, sir. Any questions? Seeing none. Any other witnesses in favor? Overflow room was opposition. In favor, but they are some for opposition. Okay, sounds good. All right, now witnesses in opposition. Any further witnesses in opposition? Again, about 2 minutes. Thank you.
Lisa Panett, Armorvine. This bill hurts the regular person. 90 days to evaluate a claim is a fourth of the year to review medical records and bills that they're sticking into an AI program to create their own evaluation. It takes only seconds to do this. This delay just allows the insurance company to keep their money longer and keep it invested. Lines 24 through 25 says that this has to be through certified mail in 2026, sending via email or being faxed should be sufficient. And I would also mention that the Department of Revenue has come saying that they do not want their documents now being sent through certified mail. And so if we want to have an equally applied standard and you're looking to do away with that for the Department of Revenue, then we shouldn't be applying it here. Lines 36 through 48 regarding the policy limit demands. Why would this list be needed of all their injuries when they're providing those medical records with their demand? They're already going to have proof of those injuries, and they're just looking for technical reasons not to pay. They're wanting a release for medical records to go on a fishing expedition, looking for any reason in their past that may hurt their client's claim. For example, maybe the client has cancer and they will delay knowing that the client might die soon. And for these reasons, we are opposed.
All right, thank you for your testimony. Any questions for this witness? Seeing none, next witness in opposition. Okay. We have one coming in from committee room 2.
Thank you, Mr. Vice Chairman, or who is the Vice Chairman? Is it? Sorry. Thank you, Mr. Vice Chairman, members of the committee. My name is Arnie C. AC Dinoff, State Public Advocate. This is one of the most ludicrous bills that I've heard this session. It is clear that this bill is being driven by insurance companies who want to make more profits over Missouri lives and Missouri people who are injured. As you can see in both rooms are highly paid lobbyists, probably 6 figures, that are paid by major insurance companies that make tens or hundreds of millions of dollars in profits from premiums. The more they save, the more commissions they get. This is about profits, and screw our 6.2 million Missourians. That's sad. Breaks my heart. This is a bad and terrible anti-Missouri resident bill. This will allow negotiations to settle naturally between parties. Let the process play out or go to court, and let a jury of the peers decide what is right and what is manageable. Testimony last night in the House Transportation Commission or committee meeting was, you lose your life as an employee of the Missouri Department of Transportation in a highway accident because somebody wasn't paying attention, and the maximum payout by the state of Missouri to that family is $500,000. That's sad. That's sad that we don't value life in Missouri. We value life at conception and newborns, but we don't value an employee of the state of Missouri that this state is only going to pay out $500,000. That's criminal. That's sad to the families that testified last night in the House committee that their loved ones who were killed, and one was pregnant with a 6-month-old,
Please
that's all that they were paid. Thank you, Mr. Vice Chairman. It's ludicrous. It's a slap in the face to families. When are we going to value Missouri lives? If we say we value Missouri lives at conception, then we need to value them until this person leaves this earth. Therefore, I have to really, no matter what, go against this bill, SB 1120. Thank you, Mr. Vice Chairman.
All right, thank you. Any questions for this witness? Seeing none. All right, last call for witnesses against Senate Bill 1120. Seeing none, witnesses for informational purposes only. All right. No witness for informational purposes only. Senator Trent, any closing remarks?
No, thank you, Mr. Chairman. Appreciate the committee's consideration.
All right. That concludes the hearing on Senate Bill 1120. Next up will be Senate Bill 865 by the senator from the 1st, Senator Beck. And I will turn it back over to the rightful chairman.
Thank you, Mr. Chairman and members of the committee. I appreciate you hearing Senate Bill 865. Thank you very much for that. I am Senator Doug Beck, 1st District, South St. Louis County, and it's a privilege and honor to represent the folks of that district. In 2005, Workers' Compensation Act was amended by the legislature, making it more challenging for employees to obtain benefits for work-related injuries. After 2005, employees had to prove that an injury occurred on the job was a prevailing factor, and in causing the medical condition or disability instead of a substantial factor. My bill brings workers' compensation law back to the substantial factor standard. Going back to this standard will bring balance back to the workers' compensation system, especially those who having received an asbestos diagnosis. Because the latency period of asbestos can be decades between the causative exposure and the actual diagnosis, many people are already retired when they receive an asbestos diagnosis, making it more difficult to prove the disease was the prevailing factor in causing their disability. Additionally, I will have a committee sub, which I submitted to you, and I believe you all have a copy of that committee sub, that clarifies occupational disease due to toxic exposure are conclusively deemed to be a total disability under Workers' Compensation Act. And on a personal note, I've seen a lot of folks since 2005 working in the construction industry that when they would get injuries after 2005, it became very, very hard for them to get treatment and some other things. And as time went on, it got worse and worse, and where they were actually forced to get lawyers to help them out. And I think if we go back to the substantial, it could clear a lot of things up, and it could help folks get that back, and maybe we start looking at as employees as assets again. So with that, Mr. Chairman, I take any questions, or we have other folks here that will answer them, or
questions for the bill sponsor from the committee? Seeing none. First witness testify in support. We may have, in fact, mirror witness testimony.
You think?
It's very possible. We're starting out strong.
I think this is a great bill. Mr. Chairman, members of the committee, my name is Randy Alberhasky, again, a personal injury work comp attorney from Springfield, Missouri. I've been doing this about 30 years, so I've been around for multiple changes in the work comp law. This bill, I think, will remedy some injustice that we've had since 2005 when we went from substantial factor to prevailing factor. The net effect of that was twofold for the most part. One, dealing with occupational injuries where people were exposed to repetitive lifting or repetitive use of their hands, carpal tunnel, that sort of thing. It basically excluded a number of older people, especially women with shoulder injuries who had degenerative conditions, women who had meniscus tears in the 50s and 60s, because they are already predisposed to those types of injuries. Men with arthritis and other degenerative conditions in their back, they have been excluded for the past 20 years from recovering under the law because of the changes going from substantial factor to prevailing factor. And I don't think, now that I'm 60, 20 years older, I don't think that's fair. I think the work comp law should cover everyone, not just the younger people in this world. And I think that was the intended purpose of the law when it was first formed 100 years ago, was to trade off, your right to sue your employer for personal injuries. Well, you're guaranteed some recovery. It was much more limited for medical care and for smaller amounts of disability, but there's a guarantee that we no longer have, that it's no longer fair. The second, I think, important change in the law this will have an effect on is that after the 2005 amendments, it no longer became possible to recover for injuries you sustained at work from mundane activities like walking and tripping and falling. That's no longer a covered claim under the Work Comp Act. I have represented individuals. I represented a nun a few years ago who was a professor at Missouri State University, and she got out of her car. She's walking to talk to the course of her work, and she tripped over a curb, fell, shattered her elbow. That was not compensable because under the law then, or the law now, if you're just doing something you would possibly do at home and get injured, that's not compensable. I don't think that's fair. I don't think that's right when she's dedicating her activities, her life to furthering her job duties.
Your time has expired, but please conclude your thought if you hadn't.
So again, I think this just makes things right again as they should be back in 2005. Even 2005, the standard was higher than what we had in 1993. So this brings some balance back to the work comp system.
Thank you for that testimony. Questions for this witness? Yes, Senator, please proceed.
I'm really interested in what you just said at the end, because my knowledge of this takes place more in the 2000s, but you mentioned that in 2005 the standard was still higher than it was in 1993. And I guess one thing we hear a lot about is economic competitiveness, but when you said that, it just kind of made me think about American manufacturing, all that was stronger, I think, back in the 80s and early 90s than it is today. And so are you saying that we were able to have an even a broader statute before 2005 that still allowed this country to compete economically like we did for so much of the...
Absolutely, and I think the reason behind that is all we did is we shifted the burden of who's paying for these injuries. We went from work comp to health insurance, or to Medicaid, to Medicare, or to hospitals. That's all we've done. We've saved businesses that some money, some types of businesses, but we've put it on other types of businesses.
Yeah, because I remember the economy in the 90s was just roaring, and you're telling me that we had that seems to me evidence that these two things are compatible, that we can have a good economy that grows jobs and also protect workers at the same time. So thank you for that.
Thank you.
Further questions for this witness? Seeing none. Further witnesses testify in support.
Good afternoon, Mr. Chairman. Good afternoon, committee. My name is Adam Reynolds. I'm with the O'Brien Law Firm in St. Louis. I'm here today to testify in favor of the bill. For the past 10 years, I've specialized in filing workers' compensation claims for workers diagnosed with mesothelioma and their families. For those of you who don't know, mesothelioma is a terminal cancer uniquely caused by exposure to asbestos, typically with a latency period that can span anywhere from 50 years to 15 years. In 2014, the General Assembly enacted what's become known as the Enhanced Benefit Law in recognition of the severity of mesothelioma. It's an absolutely excruciating disease to suffer through for these workers, and it's a terminal illness for which there is no cure. I'd like to draw a little attention to part of the bill proposed today, Section 287.020.6, which amends the definition of total disability. And this relates to these mesothelioma claims because when the enhanced benefit law went into effect, it said workers can get the enhanced benefit if they are either permanently and totally disabled or they die from the disease. Well, dying from the disease, eventually those benefits are going to accrue to their spouse because it's a terminal cancer. The problem is when they're still alive. It's very difficult to establish that a mesothelioma victim is permanently and totally disabled because the statute as it reads right now is linked to an inability to return to employment. So when you look to the language of the enhanced benefit law and it says mesothelioma must result in PTD, it's essentially saying it must result in the employee's inability to return to employment. But due to the latency period of asbestos exposure, typically these workers are in their 70s and 80s and they're already retired by the time they come down with mesothelioma. And the defense bar and administrative law judges have pointed out, hey, even though these guys have a terminal cancer, technically speaking, they could go get an office job. They weren't in the workforce at the time. They're not permanently, totally disabled. It's a big problem. I think for the peace of mind and the dignity of workers, they should be able to receive these benefits while they're still living and capable of receiving them. It shouldn't be the case where their widow basically collects these benefits after they pass away. And the worker is actually suffering through all the financial difficulties and physical pain and suffering of mesothelioma. With that, I'll take any questions from the committee.
Questions for this witness? Seeing none, thank you for being here. How many witnesses plan to testify on this bill? Looks like 3, maybe 4. 4. All right. I think we may finish perfectly then. So next witness in support.
Thank you very much, Mr. Chairman, members of the committee. My name is Arnie C., AC Dinos, State Public Advocate. First of all, I'd like to say this should be a nonpartisan bill. Doesn't matter if you're a Republican or Democrat. I'm a conservative Republican, but this is a common sense, textbook 101 type legislation. These benefit changes are needed. It's tired of our state favoring insurance companies and people who make huge profits, huge commissions, huge stock options, and we forget about the people that you were elected to serve. And so this is a pro-Missouri equitable bill. These make a lot of sense from the explanations, they're criteriaed, and they make a ton of sense. Why not compensate people for the injuries and what they've caused when they're living rather than when they're dead? Doesn't make any sense to me. This is a needed bill. It changes definitions and it covers all of our citizens in a equitable and fair, even keel playing field. I'm tired of the lobbyists being paid $6-figure dollars to come to your offices, to talk to you, to kibitz with you, to talk about all kinds of issues. But you know what? They're there for one purpose, and that's to get what they want. You were elected by 275,000 people to represent each of those people who voted in that election, whether they're a Republican, Democrat, or an independent. And I expect you to stand up for their needs, for their health concerns, for their life, and screw the insurance companies, screw the lawyers. It's time that Missourians are put first over all these lobbyists in this building. If you look at the Missouri Ethics Commission, there are 12 registered lobbyists to every elected official in this building, probably more than any other state in our nation. That's sad and pathetic. I ask that you pass this bill, SB 865. Thank you, Mr. Chairman.
Questions for this witness? Seeing none. Thank you again for being here. Further witnesses in support?
Thank you, Mr. Chairman. For the record, Jay Kummel, representing Missouri AFL-CIO. Despite my personal reservations about the bill sponsor, I'd like to go on record in support of this legislation for all of the reasons that were previously stated, but just as a personal note, as a family member that has watched somebody die of mesothelioma, it's a horrible disease. I watched my grandfather drown in his own fluids. Anything that can be done to help these family members ease through some of those things, I think we should do. So, happy to answer any questions.
No, very sorry for your loss. I can tell it still matters tremendously to you. Questions for this witness? Seeing one, please proceed.
You are a lobbyist in favor of the bill, right?
That's correct.
Okay, thank you.
Thank you.
Any further questions? Seeing none. Next witness to testify in support. Seeing none. Witnesses here to testify in opposition.
Good afternoon, Mr. Chairman. Hampton Williams with the Missouri Insurance Coalition, here to testify in opposition to Senate Bill 865. While we do acknowledge that there are some changes that need to occur in the workers' comp field, there are some other bills that have been filed which address those concerns, medical fee schedules and whatnot, which will help try to expedite those proceedings. This bill, we would be a regression. Again, what the prevailing factor does is requires that the work-related incident actually be the primary cause for an injury. It's a standard that protects small businesses. Again, we would stand in opposition as proposed. Happy to again, continue conversations with Senator Beck on this issue to address some of the other concerns in that. Haven't had an opportunity to speak with your office yet on workers' comp reform, but always happy to talk.
Questions for this witness from the committee? Seeing none, thank you again for being here. Further witnesses testify in opposition.
Good afternoon. Matthew Smith with Associated Industry of Missouri, going on opposition against this bill. Specifically, we're just concerned because of its how it upheaves the current workers' compensation system. So with that, I'd be happy to answer any questions.
Questions for this witness from the committee? Seeing none, thank you for being here. Further witnesses in opposition?
Good afternoon, Mr. Chair, members of the committee. Jared Hankinson, representing the Missouri Chamber of Commerce and Industry, here to go on record in opposition to the bill, and we'll reiterate the points that Mr. Williams made about the prevailing factor. Happy to take any questions.
Questions for this witness from the committee? Seeing none, thank you again for being here. Further witnesses in opposition?
Mr. Chairman, Brad Jones with NFIB. I do not relish the fact that I now sit in a position of being the historian for, because I don't think there was anybody else in this room that was here in '93 or '05. And I could tell you, Jake's back there laughing, but I can tell you that some of the language that was worked out in these workers' comp bills, it was loud, first of all, I remember that, but some of these definitions and whatnot, I know they were hard fought with the AFL-CIO and labor, and I will say this, some very honorable men that taught me a lot with Duke McVeigh and some of the folks in organized labor that it was a different day, and I wish those days were back because they taught us a lot, but we worked it out. I mean, now, do we need some changes? It's been a while. I mean, are there still some changes that need to be made? Probably. Life changes, you know. But yeah, I sat in those meetings, and it got interesting. But yeah, we would. I would also like to mention that just from an economic standpoint, we had a point in this state where we had about 3 or 4 workers' comp companies writing workers' comp in Missouri. And the premiums got so outrageous for small businesses that some of them had to drop their coverage. It got really, really bad. And I think that spurred on probably what happened in '93 and again probably in '05. So for those of you that are in business might remember that period of time. It was not good for the workers' comp market. It was very expensive to try and find, or if you could find it. The comp companies were just leaving like droves. So anyway, I don't want. That wasn't Bruce.
No, that sounds like
that was for you.
The committee's time is about to expire
so anyway,
here.
Thank you, Mr. Chairman.
Yeah, please proceed.
So, and we can talk more about this later, but around that time would have been when MEM was formed, kind of as a response to this.
It was, absolutely.
And
yeah.
So I guess the reason I bring that up is just that was a solution that, and I don't know all the details of it, but it was a creative solution that was found that didn't involve, that made stuff better for businesses, but didn't involve making it more difficult for workers to get help. And so I guess I would just point to that as from what I know of it, as a success story in terms of creativity and saying, hey, sometimes we look at this as like, a football field, moving the ball back and forth, but there's other things that we can do that are creative that actually can address that in a way that adds another dimension to this issue.
Senator, that MEM debate was one that you would not believe. I mean, there were people that thought that the sky was absolutely going to fall if we created this, and it was kind of a partnership, honestly, when MEM was created. I'll tell you this, I bet I've got half of my membership that's still with MEM. It is the small business market for an awful lot of the littlest guys. Yeah.
Thank you for that testimony. Any further witnesses in opposition? Seeing none. Any witnesses here for informational purposes only? Seeing none. Any concluding remarks, Senator?
No, thank you for having this, and again, I appreciate that, and kind of brought back memories of being on the House floor talking about some of these things back in the day.
Very good. That will conclude public hearing. And with no further business coming before the committee, I make a motion that we stand adjourned. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed to the contrary? The ayes appear to have it. The ayes do have it. Committee is adjourned.